Hi guys, welcome back to my YouTube channel. These are 8 important questions from the Unit 5 Winding Up of Companies and Insolvency. 1. What is compulsory winding up? Who can order such winding up, and under what circumstances? Meaning of compulsory winding up. Compulsory winding up is a legal procedure through which a company is ordered to shut down by the National Company Law Tribunal (NCLT). This is also known as winding up by the tribunal, and is governed by the Companies Act, 2013 under Section 271. In this process, the tribunal appoints a liquidator who takes control of the company's assets, pays off liabilities, and distributes the remaining assets, if any, to the shareholders. Who can file a petition for compulsory winding up? According to Section 272 of the Companies Act, 2013, a petition can be filed by 1. The company itself. 2. The creditors. 3. Any contributory shareholder. 4. The registrar of companies. 5. Any person authorized by the central government. Circumstances under which compulsory winding up may be ordered, Section 271. 1. Inability to pay debts. If a company is unable to pay its debts of 1 lakh rupees or more. 2. Special resolution. When the company itself has passed a special resolution to be wound up by the tribunal. 3. Acting against the interests of the country. If the company has acted against the sovereignty and integrity of India, or against public order or decency. 4. Fraudulent conduct. If the company's affairs have been conducted fraudulently or for unlawful purposes. 5. Default in filing financial statements or annual returns. If the company has failed to file financial statements or annual returns for the last 5 consecutive financial years. Conclusion. Compulsory winding up is an enforced closure of a company by the tribunal due to serious legal, financial, or ethical violations. It ensures that the interests of creditors, shareholders, and the public are protected by legally dismantling a company that is no longer viable or compliant. 2. Define voluntary winding up. State the various circumstances under which it occurs. Meaning of voluntary winding up. Voluntary winding up is a process where a company decides to close its business operations and dissolve itself without the intervention of the tribunal. This process is initiated by the members, shareholders, or creditors of the company, depending on the financial condition of the company. Voluntary winding up is governed by the Companies Act, 2013, and the rules made under the Insolvency and Bankruptcy Code, 2016 IBC. Types of voluntary winding up. 1. Members' voluntary winding up. Initiated when the company is solvent, able to pay its debts. Directors must make a declaration of solvency. 2. Creditors. Voluntary winding up. Initiated when the company is insolvent, unable to pay its debts. Creditors play an active role in the winding up process. Circumstances under which voluntary winding up occurs. 1. Expiry of duration, completion of purpose. If the company was formed for a specific period or purpose, and that period has expired or the purpose is fulfilled. 2. Passing of a special resolution. If the members of the company pass a special resolution in a general meeting to wind up the company voluntarily. 3. Declaration of solvency, for members' voluntary winding up. Directors must declare that the company has no debts or will be able to pay its debts within 12 months from the start of winding up. Procedure for voluntary winding up. 1. Board meeting. Directors meet and propose winding up and the declaration of solvency, if applicable. 2. General meeting. A special resolution is passed by the shareholders. 3. Creditors. Meeting. In case of creditors, voluntary winding up, a meeting with creditors must be held. 4. Appointment of liquidator. A liquidator is appointed to take charge of winding up. 5. Filing with the registrar. Resolutions, declarations, and reports are filed with the registrar of companies (ROC). 6. Final meeting. Once the company is fully wound up, a final report is submitted, and the company is dissolved. Conclusion. Voluntary winding up is a company's own decision to close its operations. It allows a smoother exit if done lawfully and provides an orderly settlement of liabilities and distribution of assets. It is a more flexible and less time-consuming method compared to compulsory winding up. 3. Explain the appointment, Powers and duties of company liquidators in voluntary winding up. Who is a liquidator? A liquidator is a person appointed to carry out the process of winding up a company. In a voluntary winding up, the liquidator is primarily responsible for managing the company's closure, settling debts, selling assets, and distributing any surplus to shareholders. 1. Appointment of a liquidator in voluntary winding up. Under Section 310 of the Companies Act, 2013, the company in a general meeting appoints one or more liquidators after passing a special resolution for voluntary winding up. In the case of a creditor's voluntary winding up, the creditors may approve the liquidator appointed by the company or appoint their own. The liquidator must inform the Registrar of Companies (ROC) about their appointment. 2. Powers of a liquidator, Section 313 of Companies Act, 2013. The liquidator has wide powers to carry out the winding up effectively. Some of the important powers include: 1. Control over assets. Take custody and control of all company assets, books, and records. 2. Settle claims. Evaluate and settle claims of creditors and contributories. 3. Sell property. Sell movable and immovable property of the company by public auction or private sale. 4. Legal proceedings. Initiate or defend any legal proceedings on behalf of the company. 5. Distribute assets. After payment of debts, distribute the remaining assets among the shareholders. Note: the liquidator must obtain approval from the tribunal for certain actions. 3. Duties of a liquidator. 1. Submit reports. Submit preliminary and final reports to the ROC and creditors. 2. Maintain accounts. Keep proper books of account and records of all transactions during liquidation. 3. Settle list of stakeholders. Finalize the list of creditors and shareholders entitled to receive the remaining assets. 4. Conduct meetings. Call meetings of creditors and members whenever necessary. 5. Avoid fraud. Ensure no fraudulent or wrongful practices are committed during liquidation. Conclusion: the liquidator plays a crucial role in ensuring that voluntary winding up is conducted legally, efficiently, and fairly. Their appointment brings the company's affairs under structured management, protecting the rights of creditors and shareholders during closure. 4. Discuss the legal provisions related to the removal of a company's name from the Registrar of Companies. Meaning: the removal of a company's name from the Register of Companies means that the company ceases to exist in the eyes of law. It is also called striking off the company. This is governed under Section 248 to 252 of the Companies Act, 2013. A company's name can be removed either by the Registrar of Companies (ROC) on certain grounds, or voluntarily by the company through an application. Modes of removal of name from register. A. Removal by the Registrar, suo motu. Section 248, 1. The ROC may remove the name of a company from the register if 1. The company has failed to commence business within 1 year of incorporation. 2. The company is not carrying on any business or operation for the last 2 financial years and has not applied for dormant status. 3. The subscribers to the memorandum have not paid the subscription amount within 180 days. 4. The company is not carrying on any business or activity, as per physical verification conducted by ROC. Procedure: ROC sends a notice to the company and its directors. Company must reply within 30 days. After considering the response, if any, the ROC may strike off the name. B. Voluntary application by the company, Section 248(2). The company can apply for removal of its name voluntarily if 1. It has no liabilities, and 2. It has not carried on any business or activity in the past 2 financial years. Procedure: 1. Hold a board meeting and then a special resolution, or consent of 75% members. 2. File Form STK2 with ROC along with required documents. 3. ROC will publish a notice in the Official Gazette and strike off the name if no objection is received. Conclusion: the legal provisions for removal of a company's name ensure that inactive or non-functional companies are cleared from the register, while also giving protection to genuine companies by providing an appeal mechanism. It helps maintain a clean corporate registry and ensures regulatory compliance. 5. ECRI Insolvency and Bankruptcy Code (IBC). What are its salient features? Introduction. The Insolvency and Bankruptcy Code (IBC) 2016 is a comprehensive law enacted by the Government of India to consolidate and simplify the insolvency and bankruptcy processes for individuals, partnerships, and companies. It aims to resolve insolvency in a time-bound manner and maximize the value of assets of such persons or businesses. Objective of IBC: to promote entrepreneurship, to ensure creditor protection, to establish a single law for insolvency and bankruptcy, to enable faster resolution of bad debts and stressed assets. Salient features of the IBC. 1. Unified framework. It combines all laws relating to insolvency and bankruptcy into a single law. Covers companies, LLPs, individuals, and partnerships. 2. Time-bound process. The corporate insolvency resolution process, CIRP, must be completed within 180 days, extendable up to 330 days including litigation time. 3. Institutional mechanism. IBC established 4 main pillars. Insolvency and Bankruptcy Board of India (IBBI) regulates insolvency professionals and agencies. Insolvency professionals (IPs), licensed professionals who manage the resolution process. Information utilities (IUs) collect and store financial data of debtors. Adjudicating authorities. NCLT National Company Law Tribunal for companies and LLPs. DRT Debt Recovery Tribunal for individuals and partnerships. 4. Creditor and control model. The control of the company is taken away from management and given to the Committee of Creditors (COC) once CIRP starts. 5. Resolution first, liquidation later. The aim is to revive the company first. Only if resolution fails, liquidation is allowed. Conclusion. The IBC is a landmark reform that has transformed the insolvency landscape in India. It has improved creditor confidence, accelerated the resolution of bad loans, and strengthened corporate governance. With its structured and time-bound mechanism, IBC plays a vital role in economic recovery and financial discipline. 6. Explain the insolvency resolution process of corporate debtors under the Insolvency and Bankruptcy Code, 2016. Introduction. The Corporate Insolvency Resolution Process, CIRP, is the legal procedure under the Insolvency and Bankruptcy Code, IBC, 2016 used to resolve the insolvency of a corporate debtor, a company or LLP that has defaulted in repaying debt. The aim is to either revive the company or, if revival fails, proceed with its liquidation. Who can initiate CIRP? Under Section 6 of IBC, the following can file an application before the National Company Law Tribunal (NCLT) to start CIRP. 1. Financial creditor under Section 7. 2. Operational creditor under Section 9. 3. Corporate debtor itself under Section 10. Steps in the Corporate Insolvency Resolution Process, CIRP. 1. Filing of application to NCLT. A creditor or the company itself files an application with proof of default. 2. Admission by NCLT. NCLT admits or rejects the application within 14 days. 3. Moratorium period, Section 14. From the date of admission, a moratorium is imposed. No suits, recovery actions, or asset transfer. No foreclosure of security interests. Moratorium stays until the process ends or company is liquidated. 4. Appointment of Interim Resolution Professional (IRP). NCLT appoints an Interim Resolution Professional (IRP) within 14 days. IRP takes control of the debtor's management and assets. 5. Public announcement. IRP makes a public announcement inviting claims from creditors. Conclusion. The insolvency resolution process for corporate debtors under the IBC, 2016 is a time-bound, structured process that focuses on reviving companies and protecting creditor interests. It has significantly improved India's insolvency framework by ensuring faster and fairer settlements. 7. Who is the person entitled to file a petition with tribunal for compulsory winding up? Meaning of compulsory winding up. Compulsory winding up is the process of closing a company by an order of the National Company Law Tribunal (NCLT). It is initiated when a company fails to comply with certain legal or financial obligations, or in circumstances where it is just and equitable to wind up the company. This is governed by Section 271 to 303 of the Companies Act, 2013. Grounds for compulsory winding up, Section 271. Some key grounds include: 1. Company has acted against the sovereignty or integrity of India. 2. Company has made a default in filing financial statements or annual returns for 5 consecutive years. 3. Company is unable to pay its debts. 4. Tribunal thinks it is just and equitable to wind up the company. 5. The affairs of the company are conducted fraudulently. Persons entitled to file a petition for compulsory winding up, Section 272. The following persons are eligible to file a petition for winding up of a company. 1. The company itself. A company may file a petition to wind itself up voluntarily by passing a special resolution. 2. Creditors. Secured or unsecured creditors can file a petition if the company is unable to pay its debts. Includes holders of debentures or other financial instruments. 3. Shareholders, contributories. Past or present members who are liable to contribute to the assets of the company can file a petition. 4. The Registrar of Companies, ROC. With prior approval of the central government, the ROC may apply for winding up under certain conditions. 5. Central government or state government may file a petition if the company has acted against the interest of the nation or public. Procedure for filing petition. 1. Petition is filed before the National Company Law Tribunal (NCLT). 2. Notice is served to the company. 3. Tribunal hears the parties and may appoint a provisional liquidator. 4. After hearing, the tribunal may pass a winding up order. Conclusion. Several persons including the company, creditors, contributories, the ROC, and the government can file a petition for compulsory winding up. This ensures that companies not operating in the interest of stakeholders or the public can be dissolved lawfully through the tribunal. 8. What is the primary objective of the Insolvency and Bankruptcy Code? 2016. Introduction. The Insolvency and Bankruptcy Code (IBC) 2016 is a major financial reform introduced by the Government of India. It provides a comprehensive legal framework to resolve insolvency and bankruptcy cases involving companies, LLPs, partnerships, and individuals in a time-bound manner. Primary objective of the IBC, 2016. The main goal of the IBC is to resolve insolvency quickly and efficiently, thereby increasing creditor confidence, saving distressed businesses, and strengthening India's financial and credit system. Key objectives of the IBC, 2016. 1. Time-bound resolution of insolvency. The IBC aims to resolve insolvency cases within 180 days, extendable up to 330 days. It avoids long delays and improves recovery of dues. 2. Maximize value of assets. Ensures that assets of the corporate debtor are not wasted or misused. Tries to preserve and maximize value for all stakeholders. 3. Promote entrepreneurship and availability of credit. By creating a fair and predictable insolvency system, it boosts business confidence. Helps promote entrepreneurship and attract investment. 4. Improve ease of doing business. A strong insolvency system is a major factor in global ease of doing business rankings. IBC has helped improve India's position globally. 5. Shift from debtor in possession to creditor in control. Once CIRP begins, the control of the company moves from promoters to a professional and the Committee of Creditors, COC. Conclusion. The primary objective of the Insolvency and Bankruptcy Code, 2016 is to resolve insolvency in a time-bound manner while maximizing value and maintaining business continuity. It strengthens India's credit ecosystem, encourages investment, and ensures that failed businesses exit in an orderly way, thereby supporting the overall economy.